Good afternoon to all of our attendees, those joining us in person on Zoom, as well as across Facebook Live, and those watching us in the future on YouTube. Welcome to another exciting NGLCC Webinar Wednesday. My name is Jonathan Lovett, Senior Vice President at the NGLCC. My pronouns are he and him, and it's my pleasure to welcome you. As we always do at NGLCC Zoom events, we encourage you in your Zoom window to click the three dots next to your camera and add your pronouns so we can make this as welcoming and inclusive a place as possible. If you have questions for our outstanding speakers today, please use both the Q&A and chat box. We will make sure there's plenty of time for questions in this important discussion today on getting paid in COVID. And as we're returning to take on, we're almost at the start of the second quarter already, and a lot of questions about how to catch up on overdue invoices, how to make accounts receivable work for you in this unusual and precarious time. And so we're so pleased to welcome two spectacular speakers to join us today. From certified LGBTBE Barnett Garcia, Matt Garcia, thank you so much for being with us. And joining us from New York, Timothy Wan of Smith, Corrode, Levy, Wan, and Parikh. I hope I got that right. Thank you, gentlemen, both so much for being with us. The screen is yours to take the presentation, and we will let you get underway. You're on mute, Matt. There we go.
Go ahead and launch the PowerPoint here, and we'll be ready to go here in just a second.
Excellent.
There we go. Share.
There we are.
Great. Well, thank you so much for inviting us to speak today. With me here today is Tim Wan. And Tim, why don't you introduce the topic and
Sure.
guide us through?
Yeah, thank you. We're very honored to be here and to be joining you today to give you some education. I am from the Commercial Law League of America, is the trade organization of attorneys and agencies that does collection law. I've been practicing for about 20 years, and I want to introduce Matt Garcia. He is a certified gay-owned business owner. He is a fantastic collections attorney. I've known him probably 15 years, and he serves on the board of governors of the CLLA. And that's how we've really gotten to know each other. We've met and we've really connected and done business together. And the thing about Matt is one of the smartest and intuitive guys I know. So Matt's going to be presenting with us today.
Well, thank you so much, Tim. And I'd like to introduce Tim. Tim is president of the Commercial Law League of America. It's a wonderful organization of debt collection attorneys and debt collection agencies. And Tim is an amazing attorney out of New York City and has been a wonderful ally to the community, to our firm, and to lots of other people that need help in this particular area.
And I just want to set the table. Before you jump into this one, Matt, I just want to set the table that what we're going to be doing today is giving you some ideas and some general information. Obviously, we haven't been retained as your attorneys, so a little bit of a disclaimer that we're not representing you. This is general information, and we would implore you to contact an attorney in whatever state you're located in to retain them for specific questions about how you should do things specifically tailored to your business. But we want to give you some general ideas to help you get paid, help you collect money, and how to protect yourself, especially in light of the COVID pandemic, which of course has put an unusual strain, to say the least, on the economy in the United States.
You know, that is so true. We keep hearing over and over again how we're all in this together. And certainly during this time, that's very much the case. But we also have an obligation to our businesses, to our employees, to the people that depend on us to protect our businesses. And my hope is, as you guys listen to some of the things that we're doing here, is that we can give you some ideas that you can take back home so that you can, to your businesses, so that you can minimize your accounts receivables outstanding and maximize your profit. And when you're doing that, you really want to avoid headlines like this. This was a headline that came out a couple of years ago. And this man was arrested by 7, not 1, not 2, but 7 US Marshals. And the headline read something like this: Houston man arrested by 7 US Marshals for not paying a $1,500 student loan debt. And what's important here is that the news didn't pick up the fact that the Houston man got a demand letter, got phone calls, got probably a notice from the lawyer saying, hey, we represent this creditor, you need to pay, got served with a suit, got a judgment against him, got notice from the court to appear, got notice that a judgment was awarded. All that came on the headline is that he was arrested for not paying a bill. So as we go through the different strategies that we're going to put forward, we want to keep this case in the back of our mind because it's important that the strategy that we develop for you, the strategy that you develop for yourself, is a strategy that works for you and protects your brand. Because if you're like me, we've spent years and years putting together our business, and it just takes one headline to kind of knock it all down. We can't all be Meghan Markle, right? I mean, she's fabulous, she's great, but there's people that are totally against what she just did and people that are totally for what she just did. From her perspective, it may be that any press is good press. But when you work on establishing a brand, when you work on starting off a business, you want to make sure that you're going to set it up right, that you get good press, and that your credit policies are in line with that. So let's talk a little bit about the credit value change. This is all of the different parts of the puzzle that you need to be looking at when you're trying to figure out how am I going to survive during COVID and how am I going to survive post-COVID. The policies that you enact today are going to help you tomorrow. The first thing that you're going to want to look at is your credit policies and procedures. With credit policies and procedures, you're going to want to look at your practices, your sales and credit policies, your standard forms, your risk, and your credit extensions. And all of this goes to basically come up with a roadmap for how it is that you're going to move forward when somebody comes to you and says, hey, I want to do business. If it's a new business, you might need to go one route and perhaps maybe have some more stringent policies and procedures for those people. Maybe you've been doing business with them for a long time, but there's been things that have been occurring during COVID that might want to make you question or put in some additional safeguards so that if you're going to do some work, that work, you know, is going to get paid. And so establishing good credit practices and good credit policies will help you develop good forms so that you can manage your risk and decide who it is that you want to extend credit to, and if so, for how much. Now, when you put together your credit policy and procedure, you're going to want to take a little bit extra time in putting together a credit application. And here are some of the things that you want to look at when you put your credit application together. You're going to want to ask about business history. How long have they been in business? Is this a new business or is this an old business? Is this one that's been established? Is this an area that is currently entertaining a lot of sales? Or is this an area that maybe isn't doing very well right now? You want to look at credit scoring. How have other companies scored this particular business? And is there any risk associated with that? If you have access, you want to do some sort of research as to whether or not this debtor has any judgments against them or any liens, or perhaps maybe they've filed for bankruptcy in the past. And then depending on how this information looks, you might then ask for a personal guarantee. And if they're willing to do a personal guarantee. Once you put these things together, now you're in a good position to come up with a decision-making process. And so your decision-making process might be, look, if it's a corporation or an LLC coming into business with me, and they're only 1 or 2 years old, I'm going to want a personal guarantee or I'm going to want to get paid before I do work. And that might be the credit decision-making process for somebody in that situation. If you've got a business that's been established for a long time and they have good credit uh, references, then you might be comfortable with maybe performing your services or selling to them on credit. Um, if it's a business that is struggling or perhaps used to be open but is now closed to the public due to COVID, and you want to continue to do business, maybe you want to ask for a personal guarantee. All of these things are important in deciding whether or not you want to move forward with extending credit. Tim, what are your thoughts on credit applications? I mean,
Sure.
some people want to just do business on a handshake. Have we lost something with that? Is there anything bad about putting a credit application and requiring your customer to sign one?
No, of course not. I think the credit application is essential for businesses that are extending credit to other businesses. But you know what? Some of the principles we're talking about here also extend to if your customer is a consumer, an individual, or the same kind of deal if you're not going to use a full-blown credit application, full-blown contract, then a contract can be formed by, let's say, a simple collection of emails. Or maybe you have a document on the front, like an intake form, and on the back of it is your standard terms and conditions that they then sign off on, your customer signs off on. Or maybe even it's a series of text messages. Nowadays, a lot of people communicate via text. But the key is that an invoice is not a contract. An invoice alone doesn't form a contract. A credit application, now that's the gold standard to form that contractual relationship, but in some cases it's not always easy. So there's a lot of easy alternatives that if you can't get a full-blown credit application or a wet ink signature, whether you're using an electronic DocuSign or you're doing it by maybe an electronic iPad where someone then scrawls their finger, or even if it's purely internet, contactless, and COVID, where it's an online click-through, where they click a box to acknowledge that they've read all of those terms and conditions, those are all valid ways to form the contractual relationship with your customers and your clients, regardless if you have a full-blown formal credit application or not. Now, but in many times, a credit application, those terms and conditions are the only thing you're going to see. So we're going to be referring to it as a credit application, but it could be any contractual arrangement where there's an offer and then an acceptance. Now, there are 4 essential terms in the credit application that you really have to think about. The first is interest. Every state has a different rule on what interest is permissible. You want to make sure that you're not violating any usury laws. Those are the laws that provide for what interest amounts are illegal. For example, in New York State, you can't charge more than 6% interest unless you're a bank. And if you're a bank, you can charge up to 12 unless there's a breach. If there's a breach, that's why you hear it's 25%. So credit cards are doing 24.9%. In the event there's a breach. That means there's a default. So you can do that in a credit application as well, where you don't necessarily charge interest upfront from day one, but in the event of a breach, you can then attach interest. For example, 1% per month per annum. That ends up being 12%, which is higher than the usury laws, but because you're attaching it on a default, it's allowed. Similarly, attorney's fees. So in the event you have to hire an attorney, many attorneys, in fact, most of the commercial law league attorneys and collection agencies handle cases on a contingent fee, which means we don't get paid unless we recover money for our clients. There's no hourly charges. There's no flat fee billing. It's purely a percentage. Maybe it's third, maybe it's 25%, something like that. So if you build into your credit application or contract a reasonable attorney's fee of 33 1/3%, in the event you turn it over to the attorney for collections, you can add that to the amount that's owed. And you can't just say the word reasonable. You've got to identify what that is, because what may be reasonable in New York may not be considered reasonable in Texas. And what may be reasonable in New York City may not be reasonable in upstate New York and Buffalo. Reasonable could be regional. And finally, costs of collection. So while we may say the attorney's fees, you're not paying me a penny unless I've collected or recovered for you, you still have to outlay costs, such as the index number to file it with the court, the process server. You have to outlay to hire the marshal or the sheriff, depending on what county you're in. So there's costs of collection, and that money can also be recovered and added to the amount owed to you if you include it properly in the credit application or contract. Of course, a warning and an important caveat is that different states do have different rules. All right. Now, in your contract, there's certain things that you have to include. correct name. So I joke around with people in my office. So my firm name is quite a mouthful: Smith, Carode, Levy, Wan, and Parikh. You know, if I was forming an entity and I wanted to hide from my creditors, I would form it something like S period space C period no space LP comma. You know, when you put in that kind of punctuation, or where the spaces are, or where the periods are, can change the ability to locate assets, can change the ability for us to file a lawsuit and identify who the customer really is. So your client, your customer may be Joe's Pizza, but probably their correct entity name isn't Joe's Pizza. Let's say it's Joe Smith, then it would be J period S period Holdings Inc. That might be the correct name of his business. So on a credit application, you want to make sure you get the proper corporate name. And what kind of business is it? Is it an individual? Is it an LLC? Is it an S corporation? That matters. Get a tax ID number as well, so you can show that it really is a real entity. Date of establishment of business, as well as in what state. We all know that certain states have certain laws and rules that may be more beneficial to businesses. There's a huge belief that Delaware has very favorable laws. So in many times, it's a Delaware incorporated entity that's doing business in another state. So you need to know these things when you set up your credit application. What is their state of organization, and where is their place of business?
And I completely agree with Tim. You know, this is so important. We had a case recently where the creditor was unable to make its case and lost out on $120,000 worth of unpaid invoices because they had no idea who they entered into business with. I know it sounds crazy. I know you're just like, well, what do you mean they had no idea who they entered into business with? The name of the business was a generic name, A Good Plumber, something like that. I won't disclose the actual name to protect the not so innocent. And so it was difficult to figure out. You know, go and search for a business name called A Good Plumber, and you're going to find all sorts of things. It's a descriptive phrase. There were emails going back and forth where one person was saying, no, don't bill a good plumber, bill a bad plumber. And then bad plumber would chime in and say, no, you need to bill a good plumber. Nobody ever decided who was going to take ownership of the bill. The creditor just ended up shipping the goods to the job site. And at the end of the day, it turned out to be a he said, she said. And the creditor had no idea who it was really entering into business with. All it knew was that it had shipped items of significant value to an address without actually doing the research to determine whether or not who they were selling to so that they could collect. Now, Tim, is once they fill out an application, should people be looking at stuff periodically, or
Right.
once you do the application, is that it? What are your
Yeah,
thoughts?
so that's a really good point. A credit application, or that initial contract, especially if you're setting up an account for a customer, you know, you could have a credit application that's signed 10 years before, and you're still doing business all during that 10 years. So one important aspect for you to keep on top of as a creditor to protect your rights is there a change in their name, a change in their ownership? Did they sell it to their child? You know, did the father sell to the son, or the mother sell to the daughter? Or did they take on a new business partner, or somebody was exiting? Did they bring in a new business partner to take over the business? Especially if you have a personal guarantee, which Matt's going to talk about in a little bit, you want to make sure that your credit application is updated to show any changes of address, changes of ownership, or changes of name. It's extremely important. Otherwise, that credit application that you spent all that time to make sure was drafted properly, that we've just talked about getting perfect, is useless if it's against the wrong person.
Absolutely. And especially during this time of COVID, we're seeing a lot of ownership change. Dad's retiring and handing the business off to son. The restaurant can't make it anymore, so they're getting investors, and now a new company is starting up. And so it's always a good idea to keep a pulse on who your customer is and make sure that if you're doing services or you're providing goods, that you know who you're providing them to.
Yeah,
Now,
and I want to hit on this one.
Tim, venue and jurisdiction.
Yeah, this is one that's extremely important to me, is having a venue and jurisdiction clause that is tailored to what your needs are, okay? And you can see the language there. This contract shall be construed under and governed by the laws of the state of whatever. In the event the customer wishes to enforce this contract, the exclusive venue and jurisdiction shall be in the state courts of the state of whatever. And that whatever is where you're located. What you don't want to see is a jurisdiction clause that fixes it in a place that doesn't work. Okay, and let me give you the example. So my son my 8-year-old son's in a karate class. We get the contract from the dojo, from the sensei, and I looked at it and I went, "Hey, did you copy and paste this from someone in California?" Now I'm in New York, and he goes, "Yeah, I did. I did. I got it from a buddy of mine who runs a dojo in California." And I said, "Yeah, I saw that because you have a clause in here that says in the event there's a breach of this agreement or any dispute of this agreement, the exclusive venue will be in the state court of California." And he said, "Oh." And I said, "So here's your other problem. Federal law says if I don't pay you, you can only sue me in the county that I reside because I'm a consumer sending my son to karate class in New York. So you have to sue me not only in New York, but you can only sue me in Suffolk County where I live. So here's the issue. Your contract says it can only be adjudicated in a dispute in California. Federal law says you can only sue me in Suffolk County, New York. That means this contract's useless and worthless. You can't enforce your contract." And he went, "Oh, can you fix this?" I said, "No problem, I can fix it for you." But that kind of thing is, he took it from a very reputable business, and it was perfect in every other way. But because he copied and pasted that language from someone else, it was a killer on his entire agreement. So the venue and jurisdiction clause is extremely important that it does serve the purpose you want it to serve.
Now, some of you guys might be thinking, Matt, Tim, this is all good information, but the reality is it takes a lot to bring a customer in the door. And especially during these times, it's hard enough for me to get work in. I just need to get it in. I need to book it. I need to do it. I need to bill it. And I get that. And I appreciate that. I'm a small business owner. Kim's a small business owner. It's hard to get customers. But here's the thing. You don't want to be doing work simply for the sake of doing work. You want to be smart about it. And if somebody's not willing to provide you with basic information like what their legal name is, that signing an application that they're going to pay, and that if they're not going to pay, there's going to be interest and charges, and providing you with service addresses and trade references, that's a red flag. And doing work for the sake of work is not good. It's not fair to your good clients who are paying, who have no problem, and it's not fair to your employees and to yourself. So be smart, take the extra time, and it could make the difference of whether or not somebody decides to pay or not. Now, the next part of our commercial credit value chain is you've got your credit application, you've got your credit policies and procedures. Now, you may want to have an additional contract or an additional type of negotiation. And that's really up to you. Many times the application and the terms and conditions that go with the credit application are going to be just fine and enough to pay you. But in other situations, you're going to want to have a more specific contract, or you're going to want to have some sort of addendum or work order or something of that nature in order to kind of put belts and suspenders. But all of that is part of your credit policy and depends on what kind of business you're in. Now let's talk a little bit about a personal guarantee. Is a personal guarantee essential to winning? And why would you want to have a personal guarantee? Personal guarantees are great if you've got a business that is either very risky because of the type of business that they're in. Say for right now, restaurants. I'm sorry, restaurants are a little bit riskier right now because we don't know what's going on with COVID. And you could have more government restrictions that could prevent you from being able to be open or not. That's a risk. If you've got a risky business, maybe the business is only 1 year or 2 years old, Maybe the business is a brick and mortar business that's been around for 30 years, but the owner is older in age, and you're concerned that the son or daughter might take it over, and perhaps they don't have the business acumen that the owner, the current owner has. In any one of these situations where your credit policies and your instincts are telling you, you know what, there's a little bit more risk here, you're gonna want to have a personal guarantee, because the more pockets you have to go after, the greater your chances are going to win. I bet Tim has a million stories, as do I, where you get a signature of the life partner of the person who went into business, and you know the person that you went into business with couldn't pay, but when you start putting pressure on the life partner, all of a sudden the money comes, because you've got another party to go after. Similarly, if you've got two people that have a business and they both have personal guarantees, one of them might end up filing for bankruptcy. If that one and only person files for bankruptcy, you may be out of luck. But having a personal guarantee of the other business partner whose name is on the hook gives you another avenue to satisfy the past due debt. So it absolutely is important. It ought to be somebody different from the customer. So it either ought to be the business owner, if it's an LLC or a corporation, or perhaps the business owner's spouse or business partner or life partner. And if you get it, it absolutely helps when it's signed and when the language is good and enforceable. So what needs to be in your guarantee? You absolutely want to discuss that with your attorney, because every state is a little bit different. But the basic information, just like in an application, is going to be a party information, that it's signed, that it's dated. You want to have some sort of language that there's consideration. And the consideration is simply this. It's very simple. You wouldn't have done the work. You wouldn't have sold them the goods. You wouldn't have entered into this transaction, but for the fact that they personally guaranteed payment of the debt. That's the consideration. If you're able to say that, and if your actions show that, then you have that greater, much more of a chance in making your recovery. And if you can get a witness or a notarization on that guarantee, that just is icing on the cake. You don't necessarily need to do that, but if you have it, it's good. It's like Martha Stewart says, it's a good thing. So witnesses and notarizations, not required, but definitely preferred. So here's a good example of something that's unacceptable and something that's acceptable. You don't want a guarantee of collection. That's going to be bad, because first you have to exhaust efforts from the customer before you can actually seek recovery from the guarantor. What you're going to want is a guarantee of payment, and that's always good, because that requires anybody to pay. You can go after the guarantor first, you can go after the customer first. It doesn't matter. You're in the driver's seat. You get to decide. So here's some free legal advice. Again, you really need to talk to your attorney to make sure that this fits with your specific set of circumstances. But here's an example of a guarantee that would generally work in almost every jurisdiction. The guarantor acknowledges that this guarantee is a guarantee of payment, and the guarantor's obligation on this guarantee are and shall at all times continue to be absolute and unconditional in all respects. And we can provide a copy of this for you guys to look at with your attorney if you send us an email. But this is a good example of how just this one simple thing could double, triple, maybe even quadruple your chances of recovery. Now, just as important as the contract, it's also important that you have some sort of documentation with respect to delivery. What is it that you do that documents whether or not you did a good job? Do you take pictures? Do you take video? Do you send an email that says something like, thank you so much for letting me work on your project? I really enjoyed it. I understand that you enjoyed my work as well and that you have no issues. If you have any issues, please let me know. I have another client that takes pictures of actually dropping the shipments at the actual job site so that they can show with a date and a time what was actually delivered, and more importantly, the conditions of the goods that were delivered. All of these things together with your invoicing procedures and how you process your payments become really important because they're part of your overall general credit and procedure and policy strategy.
And if I can just quickly interject, Matt, and that applies to not only if your deliverable is a tangible good, like Matt's referring to a physical delivery, but if your deliverable is rendering a service, whether if you're, doing an interior renovation, or if you're providing a professional service like an accountant or an attorney, or anything in between there where there is any kind of service rendered, you need some kind of documentation that you did it. Otherwise, if there is a dispute, it really becomes he said and she said.
So Tim, we've got people here, they've put together a great credit policy and procedure. They've worked with their attorney on coming together with a strong credit application and terms. And they've got some good investigation going on to making sure they know who they're going into business with and whether they're a good credit risk. And they've taken all sorts of precautions to make sure that invoices are being delivered on time, that there's some sort of proof of delivery, that we did what we said we were going to do, but the debtors or the customer is now turning into a debtor and still won't pay. What do? And how do you get the debtor to reprioritize and make you their priority instead of Joe, the plumber, or someone else down the road?
Sure. So collections is the way to go. This is going nowhere. It's time to help. Where do I go? So you need to select a third party to help you with that, to help you collect your debts. Now you've got options. You could choose a collection agency, or you can choose a collection attorney, and they have different purposes. And in many cases, collection agencies are your first stop, because a collection agency may have a national footprint. If your customer base is national, then you may want an agency who has the ability to go anywhere in the country. Whereas an attorney is going to be licensed in the state that they're licensed in, and very few attorneys are licensed in 50 states. I don't know if anybody would have the ambition to take that many bar exams. But in any event, the agencies, when you do speak to an agency, you want to ensure that they are licensed and bonded. And what does that mean? Many agencies have to be licensed in the specific state that they want to collect, and large national agencies will be licensed in all 50 states. And bonded means that it protects you. In the event the agency steals the money or goes out of business, there is a bond there to protect you from that kind of malfeasance. Now, the Commercial Law League of America is a certifying body. We will certify, as an organization, commercial collection agencies to ensure that your agency is going to be of a high reputation and properly certified under an objective standard. We also require membership by all agencies in the Commercial Law League, as well as another organization called the International Association of Commercial Collectors. But what that means is you're protected by any agency's issues. Furthermore,
let me tell you, that is really key here. I had a client who it was a $250,000 claim. They did some work on an oil field, on one of those oil wells out in East Texas. And they did so much work on it, the customer racked up a bill of over $250,000. The creditor went with a very generic collection agency. Nobody knew anything about them. They weren't really registered anywhere. I don't even think they had a listing with any Secretary of State. They gave the creditor an amazing contingency fee rate, something super small. But you know what? They collected that claim in full, and they didn't remit it all to the creditor. So of course it didn't matter that they were maybe collecting it for 5-10%, for contingency fee, because they had no intention.
No intention. They had no intention of remitting. There are no 5 or 10% contingency fees. That doesn't happen.
Exactly.
It sounds too good to be true. It probably is, right?
So, when Kim says, are they rated? Are they bonded? Are they certified? You want to go with an agency that's got a good rate, that's got a good reputation. Now, Kim, does size matter here?
No, size doesn't necessarily matter. It's got to be the right fit for your business. Look, if you are a large business that has a multinational or a full national footprint, then you probably want an agency with that kind of footprint. But if your business is largely regional or state specific, then you want to find someone that's the right size and the right fit for you. Now, I just want to hit upon the difference between a collection agency and a collection attorney. So we talked a little bit earlier about court costs, which is the index number, process server, the sheriff and the marshal, things like that. One of the things is if you have, let's say, a debt owed to you that's $500 and you're sending that to an attorney, the attorney's going to look at that and say, well, I'm going to need $500 for you to file suit. I'm going to need those costs. I'm going to need $500 from you. So you're going to spend $500 to sue for $500. Whereas an agency is more geared toward phone calls, letters, and putting legal pressure without actually filing the lawsuit on your debtor. So one size does not fit all. Now, here's some collection agency myths. The first one is you go with the lowest fee rate. You know the old adage, you get what you pay for? You do. Matt mentioned 5%, 10%. That's crazy. Industry standard is a third, 1/3 contingency fee. Now, based upon volume, based upon relationships, that can be lower or it could be higher. I've seen both. And whether or not it goes to an attorney after you go to a collection agency, where the agency tries to make phone calls and send letters and can't get it paid, they may say, you know what, it's time to sue. And then what the agency will help you do is select an attorney, or they'll select one for you. You could empower them to do that, and then they will proceed. And the fee could change, it could increase. But again, we're talking about a contingent fee, not any kind of hourly fee. Another myth, all agencies are the same. We've already said there's no two agencies are the same. They're different fits, they're different purposes. Some may focus more on commercial, business to business collection. Some may focus on retail or consumer collection, where they go after individuals on behalf of your business. And some may handle both. Not all agencies are created equal. And finally, a big myth is people are fearful sometimes, and I've heard it a lot, that people don't want to send to collections because they're afraid it's going to hurt their business. They're afraid they're going to get a bad reputation. But listen, number one, there's a big difference between a customer and a paying customer. And you're not going to get a referral of new business, a word of mouth referral from a customer who doesn't pay. Because that customer who doesn't pay you is not going to refer you to a good client. Refer a good client to you. They're going to refer you other clients who don't pay, because they're going to be able to say, hey, look, I got away with that. I didn't have to pay. So you can go take their goods or service, and you don't have to pay them. So that's what could happen. There's a big difference between a customer and a paying customer. And the other thing is, if word gets out in the industry that you're sending people to lawyers and collections, you know what that shows? That shows that you've got a high level of accountability, that you respect your business and your customers enough to know that you're willing to enforce your rights, and you're not just going to let it go. You're not going to play favorites, and you're not going to be, I'll just write this off. No, you're not going to leave it on the floor. You're going to enforce the rights of your business, and you're going to show that you're protecting your business and you're protecting your good customers, and not passing the costs that you're losing onto them.
Now, one thing you might want to do, and this is where your credit policies and your credit application and your collection, debt collection practices all start to kind of weave together like a needle and with a needle and thread. If you know you're going to use a collection agency or a collection law firm as part of your overall credit strategy, then when you're talking to your attorney about putting together a strong application with terms and conditions, make sure you put in there, remember, one of the essential terms, which is that the customer is responsible for paying all costs of collection, so that when the collection agency gets it, or when the collection attorney gets it, that 25% or 30% that the collection agency is going to charge you in the event that they recover can be passed on to your customer, so that your customer ends up having to pay the price for what they did, not you having to mitigate your loss because they didn't pay their bills.
Right. Just note on that. Remember, there's collection fees and attorney's fees. That's the contingent fee amount, and then there's costs like the court filing fees. So you should be able to add, as we said before, interest plus costs plus fees. Those are all three buckets that you should be able to include if your contract or your credit application is drafted properly. We're going to hit very quickly on the placement of accounts for timeliness. Not for timeliness of the presentation, timeliness under placement. You look at timeliness, you don't want to send it over on day 1 or day 20 or day 30. In general, you want to look at 60 or 90 days. And on the 90th day, maybe you send a letter that says, at this point, if you do not pay within the next 14 days, we're going to escalate this to our collection agency or collection attorney. And at that point, once you do escalate it and you send it to a collection agency or attorney, you want to make sure you send over all the documents. Whether the documents are your contract, the invoices, maybe there was a prior check so that in the event we get a judgment, we know where they bank already and can go seize those bank accounts. And communications, was there a dispute? Do you have a text? Do you have a cell phone number that might have a different way to get to a decision maker that isn't, the info at email address of the customer? And also make sure you give the agency authority. Tell the agency what you're expecting. So for example, let's say you're suing for $10,000. That's how much is owed. You look at that and you go, you know what? My hard cost on that was $3,000. Okay, let's say it's $3,000. And you know that the total bill is $10,000 and you're paying a third for the collection agency. So you look at that and go, okay, you know what? $3,000 is the first bucket. That's my actual out-of-pocket loss. $3,000 is the collection agency fee. So that's $6,000. So you know what? If I get over $6,000, yeah, I'm writing off some profit, but at least I'm being made whole and I'm not coming out of pocket. So give the agency or the attorney that authority so they know what to expect, because it's not going to be, you're not going to get 100 cents on the dollar plus everything every single time. Obviously, every attorney, remember, on a contingency fee, we have a unity of interest. We're in it together, right? We're like this because no one gets paid, no agency or attorney gets paid unless they collect for you. So everyone's interest is to get as much money as quickly as possible, but you want to give them authority so they know how much they should be shooting for.
Now, if the collection agency can't collect or the debt collection attorney can collect, then it's time for you to think about whether or not you need to file suit. And we'll quickly go through that. If you're going to be filing suit, you need to start thinking about and preparing for that. And if you put together a good credit policy and you have a good application and terms and conditions, and you've managed to put together some documentation, then you've got enough to share with your attorney what's going on and where you need to go and what's not being done. But remember, your attorney's coming into this kind of fresh, and they may not know the ins and outs of your business the way you do. You put your blood, your sweat, tons of time, tons of hours. You've been in this business for a long time. The attorney might not know anything about your business. So take the time to explain to them what you do, how you do it, what kind of documentation you have, and what it is that you've done up to this point to get the customer to pay. Things that you want to try to have: a purchase order or an email saying, hey, we want this service or we'd like these goods. An acknowledgement saying that the goods were received, that the services were rendered. A contract, a application for credit, terms and conditions, a statement of account, personal guarantees. These are all documents that you're going to want to get over to your attorney to have them review it. Worst case scenario, if all you have is a statement of account with copies of invoices, you can get that to them, and sometimes you can make a lot of money with those two simple things. But the more documents you have, the greater your chances of success at the courthouse. Remember, when we're putting together a statement of account, that's not just a list of open invoices that haven't been paid, but you're going to want to have something more like a check register where you have debits and credits, payments and invoices, the whole history, the whole financial accounting history of the two merchants, the customer and your company. And you're going to want that on letterhead so that you can show the judge, so that if a question comes up, well, no, I produced this payment, or I made that payment, or I don't believe that happened, but this happened. You can refer back to the statement of account, and the judge has everything that he or she needs in order to make a good ruling on your behalf. when you're putting these documents together, make sure that you take a few extra minutes to scan the documents correctly. We had a case recently where a judge went ahead and didn't grant judgment in favor of the creditor because they couldn't read the personal guarantee. The person who had scanned it got impatient and pulled the guarantee out before the scanner could actually copy the guarantee, which created a problem for the court. And so the court couldn't read the language. Now, we put on evidence of what the guarantee should have said and provided the court with a blank copy. But the fact of the matter is that the judge didn't like that, and the judge really wanted to see a signature on something that it could read. So when you're scanning documentation, take the lesson from this big company that didn't do their job correctly and take the extra time to make sure your documentation and your data is scanned correctly. So whether or not you will win at court will end up being an analysis of the documentation that we just talked about, any discovery that we make with the other side to determine if they have something that could hurt us. Maybe they have a payment, maybe they have evidence that they ordered blue carpet, but you provided them with red carpet, along with your witnesses and any legitimate defenses that the other side might have. You put all of these things together, and if everything is favorable, chances are you'll hit the arrow on the bullseye and you'll get a recovery in court. If you end up going to court, you'll end up having to have witnesses, and your attorney will kind of guide you through that and lead you through the different steps. Those witnesses might be you, the owner, or it could be the salesperson or somebody in accounting. But with the proper preparation, you'll be able to explain to the court what happened and what led you to the courthouse. Now, you go to the courthouse, you try your case. Tim, are we done? Is that it? Is that a judgment? Does that get you paid?
Unfortunately, that just wins the case. You get a judgment. It doesn't win you the war. It only wins you the battle. And you know what, Matt, just stay on this slide. In the interest of time, what I want to do is talk very just quickly in general about judgments, make sure I hit the high points, and then tell a quick story. So when you have a judgment, it gives the ability to do various things. The first big thing you do is bank searches. If you know where your customer banks and you have a judgment, in most states, you could seize their bank account. The second thing you do is seize property, especially if your client or customer has an expensive asset. Maybe they have a warehouse, maybe they've got goods that they sell, or maybe you know who they sell to, and you can restrain the funds at the customer level. Their customers, your debtor's customers, can be restrained. If your if your debtor is an individual and they're employed at a business, maybe it was the personal guarantee, or maybe your customer is a consumer, then in many states you can garnish wages. And what we then do is we serve a subpoena on the employer of the debtor and seize 10% of their wages. And those are all valuable ways in order to enforce your judgment and get you collected. So I just want to tell a very quick story that kind of sums it up and ties it together in the interest of time. So we had a judgment on behalf of a digital marketing company against a locksmith company that had a fleet of trucks, had a warehouse of safes and whatnot. We went to court, we went to trial, we won, we got the judgment, we sent the sheriff to go seize that property, and they changed their name. They sold it to a new entity, and the owner, who was the personal guarantor, filed bankruptcy, and it was sold the business to somebody else. And when we looked at it, we said, oh, a lot of people would have just closed their file, and we didn't do that. We dug a little more, we looked at it, and we found out it was sold to the owner's brother. They sold all the locations, the warehouse, and the trucks, and all that inventory for $10,000. And a new company was created 10 days before the judgment was entered by the same attorney who formed the entity, was the same attorney who was defending the case and knew the status of the litigation. So we immediately filed a new lawsuit based upon all the great information in the credit application, in the contracts that the client was able to provide us. Armed with all that, we connected the dots and followed the breadcrumbs, or whatever other kind of analogy you want to use, and we filed a new lawsuit against the new company, the old company, Both brothers, despite his bankruptcy, because we allege it was a fraud, and the attorney for perpetrating this conspiracy for fraud. We did this all for a contingent fee. And what happened within a week? The attorney calls us up and goes, let's settle the case. So because the backup was there, we were able to collect upon the judgment.
So in closing, guys, I really just want to take a step back and quickly summarize what the strategies that we're recommending. First of all, remember that work for the sake of work is not good. You want it to be good work, you want it to be profitable, and you want to make sure that there's a paycheck or some sort of check at the end of the day so that you can pay yourself and pay your vendors and pay your employees. But secondly, and more importantly, I know it's a hassle, I know it's hard, but take a step back from your business and do a little planning. A little planning today will make your future self very happy that you went ahead and put the extra work in now before things got a whole lot more difficult. Figure out what kind of work you want to do. Who do you want to work for? Who do you want to extend credit to? And at what point do you want to make somebody enter into a more formal agreement? An attorney is always going to tell you that you should have formal agreements with everybody. And that's probably the safest thing that you can do. But if you're not going to have applications and terms and conditions or actual contract, figure out who you're going to require them of and who you're not going to require them of. Make sure you understand what are the different levels of risk that you can afford to take. And then finally, have your documentation and your agency or attorney ready to go so that if your customer doesn't pay, you've got a strategy to make sure that your business and your employees and you get paid one way or another by either filing suit or, as Tim says, initiating one of the many post-judgment tools that creditors' attorneys have at their disposal. So thank you so much for having us. Jonathan, we turn it back over to you.
Gentlemen, that was fantastic. Thank you, Matt. Thank you, Tim. I know we could do this for probably several more hours. There is so much ground to cover in a topic like this. One of the questions that I received over the direct message from people attending is, what is the number one mistake you see made in getting started? I guess really, let's look at it two ways. One, getting started. You know, what are you not get enough information on from a potential client to help you get rolling, and then we're playing catch up. And then secondly, once the search for claimed assets or whatever it might be is happening, what do you want in terms of follow-up feedback and engagement? So let's start with getting involved first. How could someone who's getting ready to utilize services like yours begin that process? What do you want to see? What's the best advice there?
Sharing all the information you have. What we don't want to have a situation is you have all this stuff. You've got text messages or emails with all this juicy information. Maybe you know who the decision maker is. Maybe maybe they made this dispute before. You already resolved it and they admitted that, oh yeah, you're right. That was a mistake on our part. Ha 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 ha. Like the debtor has made that mistake and then they realize it. And now when we make a demand or we try to collect, they come back with that same dispute. Now we're repeating that work that you already resolved because you didn't send us that text message chain or that email chain, or you send us over a statement of account that summarizes the invoices but doesn't show the itemized accounting or doesn't show the proper name or something like that.
So total transparency. That's great.
The biggest mistake that I've seen is creditors, service providers, vendors simply don't do their homework when they're interacting with their customer. I can't tell you how many applications I have reviewed where the customer, who ends up being a debtor, flat out lies and gives you the social security number of somebody else, or flat out provides you with an EIN number that belongs to somebody else. And if you would just take 2 or 3 minutes to go look that up, you would know that it was incorrect. And they're basically bamboozling the creditor into giving them credit when in fact they're not entitled to credit. And so the biggest mistake I see is just not investigating. What about you, Tim?
Yeah, I'll just throw this one in there as well because it's an interesting one. Right now on my desk, I have an issue where the owner of the company is a gentleman by the name of David Cohen in Long Island, New York. You know how many David Cohens are in Nassau County alone? I think there's 12. And that's not a John Smith, right? But there's a lot of people with similar names. They didn't get a date of birth. They didn't get an age. They didn't get a copy of a driver's license. So which one is it? We don't know. And the creditor doesn't know. So that's a big mistake too, is like Matt said, not doing your homework, but knowing those little details, they matter.
So a good follow-up that came in as well that ties into that is when the potential client, the creditor who would engage you, the business owner, has a slew of information, the invoices, the contracts, all of those things that they need. What, if any, concerns should they have regarding confidentiality, NDAs? You know, some of these things might have EIN numbers, social security numbers, et cetera. How protected are they working with you in terms of attorney-client privilege, et cetera? And what do they need to consider withholding?
Someone actually asked me that question yesterday, a potential new client, and my answer is really simple. I said, how much is your claim worth? And he went, well, someone owes me about 15 grand. And I said, great, you know, my license is not worth $15,000 on your one case. You know? No, I make light of it, but the idea is this: is as an attorney, if I violated your privileged information, if I violated the attorney-client privilege, I can be disbarred for that.
Sure.
So I'm not going to risk that.
And this is where it's going to be real important that you share everything with your attorney, because if you provide those documents right off on the bat, we can review them. Also, not just in light of us not sharing that information with other people and what we can and can't share, but making sure that those non-disclosure agreements that they contain the carve-outs that we're able to collect or sue and disregard the non-disclosure agreement, because the clauses that you need that are in there, we can make sure that those clauses are there so that you can do that. Many of these agreements or confidentiality agreements do create a carve out that if the person, you know, if there's an issue with the underlying agreement or there's an issue and you have to come and enforce, there is a way that you can file suit and not be in violation of those confidentiality and NDA agreements.
Right, but a certified agency is going to have the same standards of keeping your data private and keeping your data confidential as an attorney would, and that's why there's a benefit to finding a certified agency by someone like our commercial law league, as opposed to just Googling for a collection agency.
Well, speaking of certified, that's a great chance as we're wrapping up to remind everyone, if you're not already certified, go to nglcc.org, get yourself certified as such, as an LGBT business enterprise. And for our business owners watching around the country on Zoom and on Facebook Live and on YouTube, if you need help, the NGLCC has a slew of resources for you, certified and members of affiliate chambers all over the country, including members like Matt and Bennett Garcia, who are certified LGBTBEs and big supporters of the National Legal Industry Council, as is the Commercial Law League. So let me say once again, thank you to Matt Garcia, to Timothy Juan, and to everyone who attended today. We'll make sure all of the contact information for both of their firms and our list of resources to help business owners dealing with collection, that will all be available in our Wrap Out blog on the NGLCC website, as well as on our YouTube channel. It sounds like you've got a big fan in the chat window from Carmen Blackwell, someone who might be in need of your services as well. So we're thrilled to see it. To everyone watching, remember, upcoming events include an NGLCC Sip and Pitch Friday, next Friday, March 19th. Many events coming up, including countless webinars and training programs, all on nglcc.org. Trans Day of Visibility is coming up, a very special celebration for our community you're not going to want to miss. Check out all of the terrific programs on our website, and don't forget to submit your own. We're always soliciting ideas for new webinars, new conversation topics, so don't hesitate to reach out to us at info or webinars@nglcc.org. And from all of us at the team, thank you so much. Have a great, safe week ahead. Gentlemen, thank you again.
Thank you for having us. I'm honored.
Thank you.